It's exactly 7:15, and let's just go straight to the phone lines. Let's speak to the head of communications at the Electoral Commission, Mr. Eric Kofi Jakpasu. Mr. Jakpasu, good morning to you. If you can hear me, Mr. Jakpasu. Good morning, sir. Oh, we seem to have lost him. Well, a number of things making headlines today that, we want to run by Mr. Jakpasu. First of all, I think the biggest issue is the fact that the Electoral Commission has gone to court on this issue that was ruled by the High Court for Papa Kwesi Ndum to hopefully get back on the ballot paper. But there's this other issue about pay to cover elections. The fact that in this year's elections, journalists or media houses may have to pay some amount of fee to cover the December 7 elections. Thankfully, we have Mr. Eric Jakpasu back on the line. Mr. Jakpasu, good morning to you.
Good morning, Mama Win.
Yes, sir. I hope you're well today.
I'm great. Yourself?
I am very well, thank you. The Electoral Commission is in the news a lot today, and hopefully, I have a feeling that it's going to be on for a very long time. But there's something we want cleared up. There's this news about media houses paying to cover the elections. What's the exact truth in there?
Thank you very much, Mama V, and good morning to our listeners. Media houses are not paying to cover the election. No, it's their duty, it's the mandate of the media houses to also cover, as it were, to observe the elections. The release we sent out indicated that once you have been accredited to cover the elections, you must have an accreditation tag. And all that we said is that accreditation tags will be given to those who have formally applied for it and for a fee to be determined by the commission. There is no budget covering the production of accreditation tags. So all that we are saying is that media houses will have to bear the cost of the production of the accreditation tag so that they can, with the tag, they can have access to the polling stations to observe the election. So it is not as if they are paying for observing the elections, far from that.
So how much fee are we paying for the tax?
It will be determined pretty soon, because when we have the list, we'll now engage with the producers of the card and we'll then communicate the fee to
because you've already given a deadline of November 7.
Yeah, that is for the submission of the application and the names of the person who will be going around to do the observation. Then once we get the names and we submit to the producers, then the fee will be determined and we'll communicate same to you.
But what has been done previously?
Previously, it's been the same. I think last 2012, media houses paid between 8 cedis and 15 Ghana cedis for the tag, if I'm right. I mean, there was some payment. The stipend was paid to have the accreditation tag.
So why do you think people are sort of objecting or, making news out of this time around?
Mama, I wouldn't be able to tell. It has been the same, and we're only reminding media houses again that in the same way, they may have to pay something just to cover the cost of producing the tax. We don't have a budget, and most of these taxes are also covered by donors. But GOG is not covering it, and there's no donor funding for this one. So I'm a bit surprised it should be such a big issue, and it's even been taken out of context as if we are charging for observing the election. It's just to cover the cost of producing the card.
But Mr. Jakpasu, the political parties launched their manifestos and they gave accreditation as well. We didn't pay anything to cover those events or to get accredited or to get the tax. So I'm wondering, this is a national exercise. Is in the interest of the Electoral Commission to get as many journalists on the ground as possible to make, the work easier for all of us. So why can't the Commission make a budget to cover the cost of tax for journalists?
Thank you very much. When you contrast it with political parties launching their manifesto, that was an event organized at just one place, maybe a stadium, a public place, people gather and discuss it. We are talking about producing accreditation for journalists across the country to cover about 9,000 polling stations. And we are speaking of maybe more than 1, 2, 3 journalists per polling station. That is quite a huge budget. You know, even the budget submitted for election was slashed. We couldn't get a full complement, and we've always relied on donors to finance some of these aspects of the election process. And we're saying that there's no budget for it. We don't have donor support for it. And therefore, media houses need to pay just for the accreditation time.
Mr. Owusu, my last question on this particular issue. You're asking media houses to give the names of reporters through the GJA. So should one be a member of the GJA in the first place?
Not exactly so. We're just relying on GJA to coordinate it in such a way that we can get as many as media or journalists across the country to have their names submitted to us within the stipulated time.
Mr. Japasu, this very big issue that came out, in fact, you signed a statement that was issued yesterday about the Electoral Commission going to the Supreme Courts to reverse possibly the decision taken on Papa Kwesi Ndom by the High Courts. When are you going to court today? When is the first appearance?
We have to engage with the lawyers, and in due course, all those details will come up.
But, you know, after reading the statement yesterday, one would want to ask what happened, like what changed, because I'm not sure the Electoral Commission gave the impression that they were going to go back to court, to the highest courts, really. Neither
did we give the impression that we were set from the court. What we said after Friday was that our lawyers, together with the commission, were studying the ruling, and that would come out with our position on it. You know, as at the close of work on Friday, we had not yet received the written judgment. So the position of the commission, even as stated at the IPAC on Friday, was that we will study the ruling and then come back with our position on it. And this is the position, the considered position of the commission, as advised by the lawyer.
Is the commission not worried that we probably have less days to December elections and there are other things to do, and so you want to perhaps pull everything out of courts? That was what some persons advised the commission to do, really. But to think that you really are interested in battling issues in court and prolonging things
all those advice, all those concerns have been considered, but this is the considered view or considered advice of the legal team of the commission and endorsed by the commission.
Is it not, because this is also the other side of it. Some people think that, oh, it's the chairperson's idea that we go to the Supreme Court. She's the person who is essentially trying to do all these legal battles.
This penchant to always blame everything on the chairperson is unfortunate, because we don't have an electoral commissioner in Ghana. We have an electoral commission chaired by one single person, and the decisions of the commission are collective decisions taken by all the 7 members of the commission. And in most cases, it's a decision based on consensus, not even by voting. So this penchant to always blame the chairperson for the decisions of the commission is rather unfortunate.
So I guess the reason the EC is going ahead with this is because the EC is very sure that the Supreme Court is going to rule in its favor. Because otherwise, some people also think that the credibility of the Electoral Commission comes in question here. Should you lose this at the Supreme Court?
I don't think it borders on losing credibility. You know, all these processes are means of resolving electoral disputes, and we've also maintained that they are a way of sanitizing the electoral environment and then make at the end of the day the election results much more acceptable, as all these doubts and concerns will be cleared by accepted legitimate means of resolving such disputes and misunderstanding. It is not a matter of a loser or a victor. It's a matter of just clearing the air, giving clarity to some of the issues which are not too clear with regards to the electoral process.
Finally, Mr. Jakpasu, what happens to the other courts cases that you have?
They are all in court, and what happens to them will be determined by the court. Let me put it this way. They are in court, and the court will determine what happens to all these cases which are pending.
All right, Mr. Jakpasu, we'll see what happens, and then we'll be watching closely. But we appreciate your time here on the AM show this morning. That's the head of That's the head of communications at the Electoral Commission, Mr. Eric Kofi Jakpasu. But joining Roland and myself also is Joseph Akablay. He's been reporting and corresponding on this whole Papa Kwesi Ndom court issue for us, and you were in courts when the court ruled in his favor, essentially. Can you remind us of what the court said?
So Justice Eric Cheba, in his ruling, stated that he was of the opinion that the Electoral Commission, as required by CI 94, failed to offer Dr. Ndom an opportunity to correct the mistake once the Commission identified that mistake in his nomination form, and that, he says, constitutes a breach of his human rights, and as a result of that, he quashed that decision. So that was essentially the determining factor. On all the other issues that were before the court, he disagreed with the EC as well as disagreed with Ndom. Another important thing had to do with whether there was a nomination period or not, because the CI talks about the fact that the Commission shall fix a nomination period and also a date of submission of nomination form. But the judge also pointed out that the Commission failed to fix a nomination period as required by law. But the only thing that the Commission did was to first and foremost announce that on the 8th of September, you can come and pick a nomination form, and on 29th and 30th, come and submit the form. But the Commission didn't state that the period for nomination is 8th to 30th September, such that what it will mean is that, as the law allows, people will be aware that they are supposed to present their form either on or before the deadline. But the judge again says because that was not done, they can't turn around and say that because Dr. Ndom brought it on the second day, that was on the 30th of September, you decide that you not give him an opportunity to correct that mistake because he has not brought it early enough. So those were some of the interesting things that the judge pointed out. The judge said very clearly that his interest is not in the mistake, and that is the merit of the case as to whether criminality has been committed or not. He says that is not of interest to him. What is of interest to him is whether the EC used the right procedure to disqualify Dr. Ndom. And he says, as far as he's concerned, the law gives the EC only one way of disqualifying a nominee. When the person brings a form and you identify a mistake, and you give the person an opportunity to correct the mistake, and the person fails to take that opportunity within the nomination period, that is the only basis you can disqualify someone.
All right, Roland is going to speak to lawyer Samson Ladi Ayenni, who's joining us on the phone lines.
Yeah, a very good morning to you. Now, particularly from what is being reported, that is the action the Electoral Commission and its legal team has taken, what is your own interpretation, or could likely be the preemptive approach to be adopted by their lawyers and also by the court?
Can you ask that question again, please?
What do you envisage could happen at the courts, possibly?
All right. Good morning to you and your listeners. I gather that everybody is panicking and justifiably so, genuinely feeling that the December 7th is in danger. And as you know, by the constitutional architecture, December 7th is not negotiable. And by the 7th of January, if a president is not inaugurated, I do not want to contemplate the consequences of that and what the rescuing methods will be. So people are genuinely worried. In fact, the Electoral Commission chair herself has put in some of the papers that she has placed before the court, stating clearly that she was afraid that if the suit continued in the manner that they started with Ndom, then we were heading for a situation she calls derailment of the calendar further. So people are right to feel the way they feel, including yourself, because obviously by now you would have expected that the candidates would have known their positions on the ballot paper. They would have known their positions on the ballot paper, so that as they go about campaigning, they will be telling the electorate that, look, find me at number 2 or number 1 or 3 or so and so forth. And you know that process is part of the election education that will assist in reducing spoiled ballots and all of those mistake votes. As we speak, 35 days, and they don't have that, so genuinely everybody should be concerned. But I think that whilst everybody is focusing and concentrating on the negative, there is a positive that we should also look at with the fresh case being made at the Supreme Court. And that positive could outweigh all that is going on now and could shorten all the processes, could end all the court matters, and then bring us back to normalcy to continue with the process. I would have wished, and I have said already, that when the court gave the ruling on the Indum matter, there is an aspect of the Indum matter in which the court said that you claimed you gave Indum an opportunity to make corrections, which opportunity was after you already disqualified him. The court said the opportunity required to be given to a aspirant is no opportunity if it does not end or result in amendments and corrections that are required to bring their form in conformity and in compliance with the law to allow them to be able to run. What that means for me is that the EC could have simply picked the Indum ruling and on the basis of that, call all the aspirants back and look at those who have genuine situations who are not giving the opportunity to make corrections and give them the opportunity to do so. That's what we call in our legal practice ADR, Alternative Dispute Resolution, which is allowed. But since the EC feels that that may also not be a prudent way, because it might mean giving every Tom, Dick, and Harry, including all the jokers in this process, an opportunity to be on the ballot, the best way is to go back to the court, and this time not the High Court, not the Court of Appeal, but the Court of Final, recourse, so that when the Court of Final Recourse gives a decision, that decision potentially becomes binding on all. That decision potentially clarifies all the outstanding matters to the effect that it stops, it preempts, and renders, needless any further litigation. But is it too late in the day? That's the question we need to answer. Maybe that should have been the first step that should have been taken earlier, so that by now, if that had been determined, everybody would have known their smoothness level, as they say, and then would have been proceeding. You see, the danger is that now everybody is suing as an individual. They are not going as a group, as a class action, where all of them would have had their case as one case, and then one court would have determined it once and for all within a week or 2 weeks and would have been over, and then we will proceed. Again, all of them are not filing at the same time or around the same period to allow for the court to do what we call consolidation of the cases. If all of them filed around the same time or say the same week, the court could have called all the cases and brought them together and do what we call consolidation. By that, all the cases are brought together as one, and then there will be one single judgment. But now everybody is going one after the other, and you don't know how even that may even drag further.
But Samson, preemptively, if you look at the statement of the Electoral Commission, it says the High Court did not have jurisdiction, or perhaps overstepped its boundaries as far as making that very ruling was concerned. What's really the interpretation an advisor or a legal advisor to the commission would have given?
Okay, so now you want me to get into the area of contempt of the Supreme Court. What they have put before the court, clearly, they are saying that the High Court judge, first of all, did not have jurisdiction to do some of the things that he did. So let's leave the Supreme Court to determine whether or not the High Court judge or the High Court had the power, mandate, which we call jurisdiction, to do what it did. It's not everything they are questioning. It's a portion. You see, in the ruling, the court says that on the basis of your, quote, extremely perverse action, unquote, on the basis of your, quote, fatal, incurably bad action, unquote, I have determined that you have breached the rules of natural justice. You did not give Dr. Indum an opportunity to be heard, and by reason of that, your decision is extremely perverse. Your decision is fatal and incurably bad. On the basis of that, I throw you. I quash your decision. And then he went ahead. You see, the certiorari application. There's a technicality around it. All they are saying is that the judge should have ended there when he said he has found, as a matter of fact, that the commission, in exercising its administrative duty under Article 25, did not obey the natural justice rule, which requires it to have given a hearing to the person before condemning that person. The rule simply said a person or a man ought not be condemned without a hearing. So on the basis of that, you say that didn't happen. And because that didn't happen, you have quashed that decision. Now they are saying, since you quashed that decision, you should have stopped there. The court did not have power. That's what they are alleging in the Supreme Court. To have gone ahead to say, having done the question of the decision, having thrown away that decision, I am now making an order that give Dr. Indum a hearing and let him do the corrections. After he has done the correction, accept his forms and determine whether his forms are now compliant. That is where they say we should have left it to the Electoral Commission rather than making that determination. That's where they say the court exercised excess jurisdiction. And then they say there was an error apparent on the face of the record by the manner in which some of the things were done. So let's wait and see what the Supreme Court will do. I am only hopeful that from what the Chief Justice has already indicated, we are likely to have this matter dealt with in a matter of a week or at most maybe 2 weeks. But still, the question remains, do we have the time for that? Well, we leave that to the court and to the process.
Well, thank you very much, Samson Ladiayen. And I wanted to ask you a last question, though, is about whether you think that the action of the Electoral Commission to go back to the Supreme Court perhaps is also more of a right or an opportunity to be able to consolidate its reputation because it feels its back is on the wall.
Well, questions of reputation, maybe, but I would say that what they have said, we should not be reading meanings, and I don't want to be reading meanings into, what they have said. I would rather stick to what they have said and not go beyond what they have said. What they have said is that what they are doing is in the national interest, and in fact, the constitutional article under which they are seeking to do what they are doing actually also calls for you to be able to demonstrate a certain public or national interest. Other than that, you will not even be entertained because an appeal as of right from a decision of the High Court lies to the Court of Appeal and not to the Supreme Court straight. So by what they are doing, they are going through a process which the law clearly states the grounds for which you can come and for which you will be heard. So I trust that that is the only reason they are going. And again, you know, let's look at it this way again, that you remember, for example, on Newsfile, that when I asked the question that to the Indum's lawyer, I asked him, are you saying that when people have done things that border on criminality and the EC detects these things on their forms, are you saying the EC should give them opportunity to make corrections of matters bordering on criminality? And I'm sure you would have followed how Aiko to fought me on that and simply insisting that I shouldn't be asking that question. That is a question he is now going to the Supreme Court to answer. So if the Supreme Court is able to bring finality to the issue, you will realize that it will apply to almost all the candidates that have been disqualified in the case. And it will be binding on everybody. It is not a High Court decision. It will be a Supreme Court decision. It will be binding on everybody. Again, it will bring certainty to that kind of process going forward, so that we all know that if someone brings their form, the errors that the EC is allowed or permitted by law to allow the candidates to come back and make corrections are these categories of errors and not every and any error at all.
Okay, thank you very much. Samson Ladi Ayenedi is a legal practitioner. He's also the host of Newsfile on Joy News as well as Joy FM. Well, we thank you very much for that. But Mamavi, it looks very interesting, and very soon we'll be speaking to the PPP as well for them to get a certain perspective on the subject.
Yeah, it does. And we do have Richard Niama, who is Executive Director of the PPP, joining us via phone. Good morning to you, sir, if you can hear me. Thanks for your time.
Good morning, Mamavi.
Yes, sir. So it looks like your legal battles are not over yet, just when you were getting back on track with the campaign.
Well, let me say good morning to viewers and apologize for my inability to get into the studio. But our campaign had never stopped at any point in time. In fact, even when the court case was ongoing, we were still campaigning, and we were moving around doing everything as normal as we were, except that on the days that the court started, some of our members thrown to the court premises to show their solidarity. And so that is to say that even though the EC has decided to go to the Supreme Court, it will not put our campaign on hold, because we are a very focused political party and we continue to do the things that we want to do. It is important to say that today, as we see, our flag bearer, Dr. Papa Kwesindum, is on his way to Rara in the Volta region, where he's going to outdoor a new industry that will provide jobs for over 4,000 people in the Rara community, which is called the Ejumera Rice Project. They are going to produce a locally produced rice that has been nailed to the standards of international rice, and it's going to provide businesses and jobs for a lot of Ghanaians.
Okay, but Mr. Ama, what's his reaction to the fact that the Electoral Commission is headed to the Supreme Court?
Well, let me say that they have the right to do so. In fact, our lawyer, Owusu, stated that if the High Court had not ruled in our favor, we would have gone to the Supreme Court. So I don't think we are about to begrudge the EC for going to the Supreme Court. It is within their right, and they have every right to do so. The most important thing is that they are the elections management body, and they are the ones who are crying for time to do their work. So we would have expected that when the High Court gave that a very intelligent ruling, the EC would have called all the other candidates who are also in court and said, look, we want to revise the rules. All of you come and correct your errors and let's move on, so that we'll have time to do the things that they are supposed to do. But unfortunately, they want to fight on every little right that is left with them. And it is quite surprising to us. We do not want to comment on the substantive matter that they have taken to court because our lawyers have taken it up. I'm sure today they will be served. Yesterday they were not served, and so we do not even have the official document from the EC. But I believe today they will be served, they will study it, and they will respond to it appropriately. We know very well that our rights are not going to be trampled upon by the EC's inability to interpret its own rules, and so we are not worried at all. We just want to tell our supporters to have faith in the legal system and to know that no matter what happens, Dr. Papa Kwesi is still going to be on the ballot paper, just as our parliamentary candidates are also going to be on the ballot paper, and we are going to win this election.
But this surely brings some kind of uncertainty to your camp, doesn't it? Because I remember, even though you did mention that the campaign was still ongoing, even when you were battling this case at the High Court, there were some concerns that the headlines for the PPP always was not on what you were doing on the ground with regards to the campaign, but with the court case. So this certainly is going to destabilize the activities that your candidate is undertaking.
Mama V, I believe it is the democracy of Ghana which is under threat. If we have an electoral management body that decides to behave in the way our current electoral commission is behaving, I don't think it is the PPP which is destabilized, but I believe it is our democracy which is under threat. That is why when we won the case at the High Court, our flag bearer, Dr. Papa Kwesi, mentioned that it is not a victory for the PPP, but it was a victory for the democracy of Ghana. You see, all over the world, it is the voters who decide whether someone should be president or not. And let's also get it. The Electoral Commission is not a court. The Electoral Commissioner cannot declare somebody to be criminal. Neither can they declare any act to be criminal. And I'm sure Madame Salotose is a lawyer and she knows what I'm talking about. The mere fact that I suspect you to be a thief does not make you a thief. And so we are surprised that the mere fact that Salotose suspects that Richard Aseda signed twice, she has decided to, based on that suspicion, to pass a judgment on the PPP and to punish us. When the law is very clear in Article 12, 14, and 19 of the Constitution that nobody can be punished for an offense unless that person has been tried in a competent court of jurisdiction. So I am surprised that the EC is talking about criminality at this point in time when they know that it is never going to work in any court of law in this country. We have been to the CID. They arrested Richard Aseda. He wrote his statement, and on that same day, they granted him bail. It is up to the police to decide whether they will prosecute him or not, if they think there is enough merit in what the EC is saying. And now listen to me. During Afarijan's time, if you submit your nomination form, the 4 documents, you are given one to hold, and then the EC will take the tray into their ICT room to make all the cross-checks. Then they will come back to compare it with what you are holding to ensure whether there are errors in it or not before they allow you to go. Now, during this current EC time, when you go to submit, they take all the 4 from you. And as I speak to you, they took our 4 nomination forms, held it for 10 days, only for them to come back and tell us that there are some names in it which are not correct. You expect us to agree with them? I'm surprised they are taking this matter to the Supreme Court. And I believe that they are going to meet their second embarrassment over there, and we will all see that in Ghana here.
Finally, Mr. Ama, have you been served? Do you know when you're appearing?
Well, like I said, we all heard from the news yesterday, and I believe our lawyers will certainly be served today because it's a very serious matter. And once we are served, we shall also study the processes and respond appropriately.
Mr. Richard Ni Ama, Executive Director of the PPP, we wish you well with this case, but we'll have to end our conversation here. Thanks for your time.
Thank you very much.
All right. So you're here with us. What's the plan? We don't know when we're going to court again, right?
Yes, and it's a bit surprising when I heard the news myself, because when the judge gave his ruling and asked for comments from the lawyers on both sides, Ayuko to thank the judge, and same with Thaddeus Sorry, and he was very emphatic in saying that they are most grateful, they disagree, but they understand that is a decision of the court. So then again, but they still have that right, so you can understand why they'll decide to go back to court. But already this morning there are 3 cases up at the court, that of the PNC, we also have that of the NDP. The NDP, this is the 2nd time they are in terms of appearance in court. This is the 3rd time, but this is a fresh suit. So this is the 1st time they are showing up, and that fresh case that they filed after the earlier one was dismissed by the court, whilst the PNC will also be making a first appearance. And for the APC, today they will be going to hear from the judge a date for ruling.
It's interesting because I heard Mr. Ayariga say that they had a better case than Papa Kwesi Ndom, and now that we're going back to the Supreme Court, I wonder what he would say. But did Mr. Ayariga too? I think I heard him say he wanted the court to cost the EC.
Yes, in actual sense, that was still after the ruling was delivered, and he mentioned that it was just the day before that the EC had been awarded a cost of 10,000, that is from the NDP. So he requested for 20,000 cedis to be awarded to the Progressive Post Party, Dr. Papa Kwesi Ndom. But then again, Thaddeus Sori made a point that you came to court seeking a relief and that has been granted. So why do you want cost to be awarded? And in fact, Ayuko rose up again and he mentioned that he always considered the battle to be that between a father and a son. So he has decided to waive the bit about the cost, and the court decided not to grant it as well. Amazing.
Here we are. So you go back to court when we know when there's an appearance, and you come back and report for us, right?
But I'm on my way this morning anyways.
Oh, yeah, of course, with the 3 other cases. And talk about the PNC, and we have Mr. Bernard Mona who will join us for a conversation. We'll talk about their court case as well. Joseph Akable, thank you very much. See you later in court like I'm the judge. We'll be on the other side. Stay with us. You're watching the AM show. It's just 51 minutes after 7.